A group of women is taking the Ingonyama Trust to court. They say they were tricked into signing leases on their ancestral land. Mawande Kheswa was in Pietermaritzburg to find out more.
It's been quite a busy day in the High Court in Pietermaritzburg, where we are hearing arguments around the issue pertaining a group of women who say that they were tricked into signing leases with the Ingonyama Trust. And these leases were previously known as PTO's permission to occupy, and that was a system that was being used previously. Then it changed into a system where the Ingonyama Trust introduced leases into the picture. I'm going to speak to Lawson Knight, who is representing the applicants, to just give us a little bit of information on what the applicants are looking for in this case, and how strong do you feel about this case that has been brought forward?
Thank you. Well, the application has really been brought because what the Ingonyama Trust has been doing is converting customary law rights to the land, which are perpetual in nature, can be passed on from generation to generation, and the land has sat with these communities for centuries now. The Ingonyama Trust is now seeking to convert those into 40-year lease agreements, forcing people to pay rent on that land, which they've never had to do before, with annual increments of 10% on the rental each year. And we're challenging that and want the court to set aside the validity of those lease agreements. We're arguing that they're unconstitutional because they undermine the customary law rights to the land.
What effect would this have from a perspective of looking at the system in its entirety? I understand that there are about 7 applicants, if I'm not mistaken. Outside of them, what effects would this have?
Well, it has an impact on everything that the Ingonyama Trust would do in the future. So if we are successful in this case, they will have to cease issuing lease arrangements. All the leases that have been entered in so far will have to be scrapped. And the issue that was being debated in court just now by the Judge Olson, he raised the issue, well, if we set aside this, what should replace it? And he was saying that the old permissions to occupy would not be a sufficient guarantee of rights, because customary law rights are much stronger, and that a new system would need to be put in place by the minister to ensure the security of tenure of communities who reside on this land.
Thank you very much for your time. We have been speaking to Lawson Knight, who is representing the applicants in the matter.